Hearing in the appeal Barclays Bank plc against various claimants.
Lord Fox, before we begin, I'll just remind everybody that there is an anonymity order in this case. I feel sure that there's absolutely no risk of anybody referring to any of the claimants by name, but nevertheless, the court has ordered that no one shall publish or reveal the names or addresses of the respondents who are involved in these proceedings, or publish or reveal any information which will be likely to lead to the identification of them or of any members of their families in connection with these proceedings. I say that because, of course, these proceedings are live streamed, and the risk of accidental lapses is the greater as a result, but I feel sure there isn't in this case.
My lady, can I just, I've been asked just to mention that in the bundle, particularly in Appendix Part 2, some of the statements have not been fully redacted, and therefore there is that slight risk, and I just was asked to draw attention to that.
Thank you, Ms Gumbel. Thank you.
My Lady, my Lords, I appear on behalf of the appellants Barclays Bank, together with my learned friend Mr Futrell and my learned friend Miss Ayres, and for the respondents are Miss Gumbel QC and Mr Keller QC. My Lady, my Lords, the issue identified by the judge at first instance was this: there should be a trial of the following preliminary issue, namely whether the defendant is vicariously liable for any assaults that any claimant may prove to have been perpetrated by Dr. Gordon Bates in the course of medical examinations carried out at the request of the defendant, either before or during their employment with the defendant. She was the judge in charge of this group action, and she identified this as an issue for a preliminary trial. Mrs. Justice Nicola Davis, as she then was, concluded that there was vicarious liability in these circumstances, and the Court of Appeal, with Lord Justice Irwin giving the leading judgment, agreed. The appellant's case before this court is that Dr. Bates was an independent contractor. Both sides agree that he was not a conventional employee. Although a considerable amount of recent case law has transpired on vicarious liability in recent years, the Court of Appeal, through Lord Justice Irwin, said, quote, "There has not been a decision which squarely addresses facts such as these." And that, no doubt, is the reason that this case is before the Supreme Court. My Lady, my Lords, we are aware that this court, as constituted today, has recently heard another case about vicarious liability, the other of the two stages which have been identified by the courts. So I know that the court is familiar with the main cases, so I hope that that will make my submissions rather shorter than they might otherwise have been. Well, the facts need very little elaboration. They're set out in the Statement of Facts and Issues. But before moving on to the authorities, I'd like to make one or two very brief comments about them. Firstly, I'd like to make it clear on behalf of my clients how much they regret any abuse that any claimants suffered at the hands of Dr. Bates. The allegations date from the end of the 1960s until about 1984. The Northumbria police inquiry was launched in 2013. As soon as Barclays became aware of this, they consulted their records and wrote to all those whom they could identify as having been medically assessed by Dr. Bates, offering support and counselling. My Lady, my Lords, both sides have endeavoured to minimise distress to claimants. Originally, there was to be a trial with oral witnesses on both sides. It was agreed, however, that the preliminary issue could proceed without live evidence, thus, of course, reducing distress to the claimants and indeed all witnesses on either side. My Lady, Dr. Bates carried out his practice, as was quite common then and indeed now, from his home at Fenham in Newcastle on Tyne. His son lived at home with him throughout the relevant period. He died in 2009. Before the police investigation, all this litigation had begun. So the evidence from Barclays comes from former employees, quite considerably former employees of Barclays, and from his son Nigel. One aspect of the facts not referred to by the courts below was that the work that Dr. Bates did for Barclays was a comparatively minor part of his overall practice. He worked at the hospital. He had a particular expertise as a chest physician. He did emigration medicals. He worked for insurance companies. The MMI has been identified as one, mutual insurance company, a government board, and he even wrote a newspaper column. The numbers of potential employees he saw fluctuated according to the amount of jobs that were in need of filling at Barclays. He received no retainer, but was paid on an ad hoc basis. There was no contract as such guaranteeing any particular number of examinations on his part. My lady, the determination of this case has not, of course, been assisted by the passage of time. If this claim had been brought in, say, the 1970s, Dr. Bates would have been the obvious defendant. It is likely that he would have been able to satisfy any judgment. He has died, as I've indicated, and his estate has been distributed. Barclays, on the then state of the law, would not, we submit, have been liable. Even if they had been, they would have had a remedy over under the 1978 Act or its predecessor in common law for an indemnity against Dr. Bates. As it is, Barclays are effectively the last man standing, or is the last man standing. There are a number of other difficulties about the facts. What happened in terms of medical examinations at the time? Now I think it's probably the case that someone in the position of the claimants would have been offered a chaperone at the hospital, at the general practitioner's house. That was briefly raised as an issue at first instance, but Lady Justice Nicola Davis immediately said, well, that wasn't the practice then. And of course, she had experience, her own experience, and also considerable experience as a practitioner in this particular field. That an employee is not liable for the torts of his independent contractor is described in a number of cases of high authority.
I think you mean employer.
That employer is not liable, you're quite right, lady, is not liable for the torts of his independent contractor is described in a number of cases of high authority as, inverted commas, trite law. The Court of Appeal, however, took the view that asking whether a tortfeasor was an independent contractor was, since Cox and Christian Brothers, asking the wrong question, or as they put it, it was no longer the test. There has been much academic criticism of the Court of Appeal's approach to this case, and we've referred to quite a lot of it in our printed case, and it is in the Appeal Bundle 3. I won't get a chance to take the court to all the articles, suffice it to say that they have different views, but for the most part they are critical of the analysis. However, I will, if I may, take the court to the principal cases and highlight one or two passages which we say are of importance. Lady, may I begin by inviting the court to look at the case of Lista, which is MS 42, which is at tab 6 of the authorities bundle.
And have you a page?
I'm sorry, my lady?
42.
Have your page?
The page is the head note, first of all, which is at 482. My lady, the law used to be on vicarious liability that it was necessary to prove that the tortfeasor was employed by the defendant and that the tort was committed in the course of his employment and that the employee was not on a frolic of his or her own. Until Lista, that was the orthodoxy. Of course, there were many cases at the margins as to whether somebody was acting in the course of their employment. The case of Lista, which I will only refer to briefly and for one particular purpose, was of course concerned with what we now describe as the other stage in the analysis on vicarious liability. The claimants who had emotional and behavioural difficulties were resident in a boarding house attached to a school owned and managed by the defendants, and the warden of the boarding house was employed by them. So employment was not an issue in this case. Unfortunately, the claimants were abused, and the question was whether there would be liability, notwithstanding that plainly what the warden did would have been outside the scope of his employment. The case of Trotman represented the then orthodoxy, and the House of Lords reversed that decision, coming to the conclusion, allowing the appeal, that having regard to the circumstances of the warden's employment, including close contact with the pupils and the inherent risk that it involved, there was a sufficient connection between the work that he'd been employed to do and the acts of abuse that he committed for those acts to be regarded as having been committed within the scope of his employment. And the court had before it some judgments from the Canadian Supreme Court, which clearly had an influence on the analysis. And I'd just like to take the court to one or two brief passages. And the reason I do so is because they do refer to the Canadian authorities, and my learned friends in their written case place some reliance on the principles that one can extract from those Canadian cases. And I would wish to temper somewhat reliance on general principle unless it fits in with the proper legal analysis, which we say follows from the various cases, Lista and those that follow. At MS 487, paragraph 2, there is a description of the home, the fact that the appellants were aged between 12 and 15, and they had emotional and behavioural difficulties. It was, as it were, a home away from the school. At page 497, Lord Steyn refers, and this is at paragraph 27, refers to the application of the correct test. And he says that he had been greatly assisted by the luminous and illuminating judgments of the Canadian Supreme Court in Bazley and Jacobi, and said that wherever in future these judgments, the matter will be considered the common law, these will be the starting point. He did say, on the other hand, it is unnecessary to express views on the full range of policy considerations examined in those details. Employing the traditional methodology of English law, I am satisfied that in the case of the appeals under consideration, the evidence showed that the employers entrusted the care of the children in Axel Home House to the warden, and then stated the question is whether the warden's torts were so closely connected with his employment that it would be fair and just to hold the employers vicariously liable. At I should start at 503, Lord Clyde said this at paragraph 48. Cases which concern sexual harassment or sexual abuse committed by an employee should be approached in the same way as any other case where questions of vicarious liability arise. I can see no reason for putting them into any special category of their own. That's a theme which we say can be extracted from subsequent cases too. Intense sympathy one may have for the victims of sexual abuse, but the law remains the same, regardless of whether the tort is of sexual abuse or some other tort. Lord Clyde also, on the opposite side of the page, refers to the facts of Bazley and Curry, and also the facts of Jacobi and Griffiths, just above letter C, where a different conclusion was reached. In that case, vicarious liability was not established. In that case, the act, with one minor exception, took place in the employee's home outside working hours. That the club, he says, had provided an opportunity to establish a friendship with the children did not constitute a sufficient connection. At page MS 509, Lord Hobhouse commented on the Canadian jurisprudence, and he said, this is at 509, just below letter B, beginning similarly, I do not believe it's appropriate to follow the lead given by the Supreme Court in Bazley and Curry. The judgments contain a useful and impressive discussion of the social and economic reasons for having a principle of vicarious liability as part of the law of tort, which extends to embrace acts of child abuse. But an exposition of the policy reasons for a rule, or even a description, is not the same as defining the criteria for its application. Legal rules have a greater degree of clarity and definition, and is provided by simply explaining the reasons for the existence of the rule and the social need for it. Instructive though that be in English law, that clarity is provided by the application of the criteria, which I have derived from the English authorities. And then finally, from Lista, Lord Millett at MS 5117, where he was discussing the warden's duties, and he said in the present case, the warden's duties provided him with the opportunity to commit indecent assaults, but that in itself is not enough to make the school liable. The same would be true of the groundsman or the school porter, but there was more to it than that, and he then went on to discuss what more there was, and concluded just above letter C, it's not necessary to conduct the detailed dissection of the warden's duties of the kind on which the Supreme Court in Bazley and Jacobi embarked, but he would hold the school liable. Now, I concede at the outset that this is a stage 2 question, not in issue before the court, but of course, being the first big change in the law of vicarious liability in tracing the origins back, it's important to see how the law has developed. The next case, which I would like to take the court to, is E and English, which is at MS 399 or tab 4 of volume 1. This was a decision of the Court of Appeal in 2012. The claimant was abused by a priest who had been appointed by a diocesan bishop. The Court of Appeal, by a majority, found that there was vicarious liability on rather different grounds than were the basis of the judge at first instance decision. And the Court of Appeal so concluded on the basis that the relationship between the bishop and the priest was akin to employment. The lengthy and scholarly judgment of Lord Justice Ward was commented with approval by Lord Phillips when he came to consider it in Christian Brothers. There are just one or two brief passages I'd like to take the court to, if I may. At MS 445, Lord Justice Ward was seeking to try and draw the strands together, and this is at 445, paragraph 69, seeking to draw together what the test might be to establish a relationship which was akin to employment. He said this: there being no single test, what one has to do is to marshal various tests which should cumulatively point either towards an employer-employee relationship or away from one. Adopting that approach confirms that which is accepted as the common ground, namely that Father Baldwin is not a true employee. The test may yet be useful to see whether he can be said to be an independent contractor. For if he is, the law is clear. The employer is not vicariously liable for the torts of his independent contractor. Now that, we say, represents a clear statement of principle well established for hundreds of years. I am satisfied that Father Baldwin is no more a true independent contractor than he is an employee. For a start, he had no contractual relationship with his bishop. He is hardly a person in business on his own account. with a free hand to carry out the job, if it is a job, as and when he wishes. Whilst it may be useful to carry out some sort of comparative exercise for the purpose of ascertaining how close the relationship of Father Baldwin and the Bishop is to the relationship of an employer-employee as opposed to that of an employer-independent contractor, my judgment is that one should concentrate on the extent to which, if at all, he is in a position akin to employment. The cases analysed in the immediately preceding paragraph should be noted with a view to abstracting from them, if it is possible, the essence of being an employee. To distill it to a single sentence, I would say that an employee is one who is paid a wage or salary to work under some, if only slight, control of his employer in his employer's business. For his employer's business, the independent contractor works in and for his own business at his risk of profit or loss. We submit that that is a correct analysis of the law as it stands. The decision reached by the court, as I said, was not unanimous, but Lord Justice Davis agreed, Lord Justice Tomlinson dissented. There is perhaps one other passage which I should refer to in passing, which is at MS 449, at paragraph 81, and I won't read it out, but during the course of the paragraphs 81 to 83, he describes how, standing back, that his analysis of Father Baldwin's position is that he's more like an employee than an independent contractor, and his relationship is close enough, so akin to employer-employee. Now, the court said that they found this case extremely difficult to decide. In that, I think they're not alone in that judges have frankly confessed that this is an area where there are often no clear and obvious answers. And if we go to page 465, MS 465, Lord Justice Ward acknowledged that. He gave some encouragement to the possibility of an appeal to this court, but that's a passage at page 100, at paragraph 137. However, the court dismissed the application, and it may be partly I don't know, that the application was dismissed because the court was shortly to hear a similar case, namely Catholic Child Welfare Society and various claimants, which I now wish to turn to.
Just before you do, looking at paragraph 81, Lord Justice Ward, I think, seems to suggest that it's not a binary choice between independent contractor or employee. He seems to suggest that those factors, whether he's more like an employee than an independent contractor, that one has to approach it in a rather more nuanced way. You don't simply say the dichotomy is between whether this person is an independent contractor or whether he's an employee. You have to look at the features of the engagement, if I can put it that way, and see whether they partake more of the flavour of independent contractor than that of an employee. Would you accept that?
I would accept that in the sense that what he is looking for, we submit, and correctly so, is when one is examining a relationship which is not obviously employment in the traditional or well-understood sense, is it more like employment than it is being an independent contractor? Is it akin to employment? There are some cases, such as with the priesthood, which defy the binary classification, as it's put in some of the articles. But nevertheless, despite accepting what my Lord says by hypothesis, we nevertheless submit there is a clear dividing line between a relationship of employment or akin to employment and that of an independent contractor.
It's implicit in what he says in paragraph 69 that he took us to, first of all, that there clearly is a category of employees and there is a category of independent contractors.
Yeah.
And vicarious liability exists for employees. It doesn't for independent contractors, that's what he's saying. But he's also accepting that there are that those two categories don't exhaust the field, and that there are some people like the priest in that case who can't be classified either as an employee or as an independent contractor, and you then have to decide which they are more akin to for the purposes of applying this doctrine.
Indeed, my Lord, I accept that, and indeed that's reflected, I think, in the analysis of this court in the case of Cox, which we're going to come to shortly, the prisoner working in the prison kitchen.
Yes, I mean, so it's not an entirely fluid, continuous spectrum, as it were. That there are these definable categories on his approach. I mean, if somebody is an independent contractor, that is the end of it. The doctrine does not apply. If he's an employee, that's equally decisive. The doctrine does apply. And the problematical area is when you're dealing with people who fall into neither of those categories.
Yeah. We submit that is the appropriate characterization of his conclusions, and we say that that is the law. And it's understandable that the courts have responded to cases which are not easy to fit in to one or the other category by looking carefully at the relationship, deciding whether it is more akin to employment or whether, in truth, there is a relationship of independent contractor. And that's been particularly appropriate because of the changing nature of employment that we see nowadays, in that somebody might be described as an independent contractor, but in truth, on proper examination, they are, in all effects, an employee. There may be some tax advantages or other advantages to the employer, and it's usually the employer who has the advantage in describing them as being an independent contractor or not truly an employee. But in truth, the court may, on certain facts, decide that an employee is the proper or the much more appropriate way of labelling them. And in fact, the court in this case had a useful article which from McKendrick describing the various different forms of employment which now exist in the modern world, which I think influenced his analysis and indeed is one of the articles that are before this court. If I may, and my lady, I was going to go on to the Catholic Child Welfare Society case, which is at MS 355.
That's the one that you earlier referred to as the Christian Brothers case.
Yes, it's referred to in different ways by different judges. If I can refer to it as the Christian Brothers, but I think its official title is various claimants.
I think that's a little bit shorter.
Yes, very well. Christian Brothers it is. Now, this case, in this case, there were two potential defendants. Abuse had taken place at a school in Waiton, and the two defendants were either the Institute, a Roman Catholic order, which sent its brothers to live and work at St. William's, or the diocesan body that, by statute, were responsible for running the school. The court at first instance and the Court of Appeal decided that the diocesan body was vicariously liable, but that the institute was not. The Supreme Court, however, came to a different conclusion, and they looked at the nature of the institute as a lay Roman Catholic order, what its mission was, its code of conduct, its vows, the fact that they renounced salaries, and I'm looking at the head note at 355, that all the brothers' material needs were met by the Institute, and that the diocesan bodies responsible for managing residential school left it to the Institute to nominate a brother to act as headmaster and appoint other brothers to teach there. So the court considered, and there was only one speech, one judgment from Lord Phillips, and if I can take the court to MS 369, at paragraph 34, Lord Phillips was considering what has now come to be known as stage one, the essential elements of the relationship. And at paragraph 35, he says this: "The relationship that gives rise to vicarious liability is in the vast majority of cases that of employer and employee under a contract of employment. The employer will be vicariously liable when the employee commits a tort in the course of his employment. There is no difficulty in identifying a number of policy reasons that usually make it fair, just, and reasonable to impose vicarious liability on the employer when these criteria are satisfied." And then he goes on to list 5 reasons why, and those reasons have been elevated somewhat into tests in subsequent cases, and we will revisit them. He then goes on to deal with the point that the significance of control, and it appears that the questions of control are probably less important than they used to be. He says this at paragraph 36: "In days gone by, when the relationship of employer and employee was correctly portrayed by the phrase master and servant, the employer was often entitled to direct not merely what the employee should do, but the manner in which he should do it. Indeed, this right was taken as the test for differentiating between a contract of employment and a contract for the services of an independent contractor. Today, it's not realistic to look for a right to direct how an employee should perform his duties as a necessary element in the relationship. Many employees apply a skill or expertise that is not susceptible to direction of anyone else. It's the company that employs them. Thus, the significance of control is that the employer can direct what the employee does, not how he does it." Can I take the court on to MS 374? And in particular at paragraph 57, where Lord Phillips says this: "The relationship between the teacher brothers and the institute differed from that of the relationship between employer and employee in that the brothers were bound to the institute not by contract but by their vows. Far from the institute paying the brothers entered into deeds which they were obliged to transfer all their earnings to the institute, but the institute catered for their needs from these funds." And then he said importantly at paragraph 58, "Neither of these differences is material. Indeed, they rendered the relationship between the brothers and the institute closer than that of an employer and its employees." So it went, in his view, as it were, further down the line towards employer-employee and away from the independent contractor situation. Now, it is notable, and I won't take the court to it, that Lord Phillips is very polite about Lord Justice Ward's judgment in E versus English and the degree of scholarship that it evidences. But in view of the clear statement of the law, which I've taken the court to, and Lord Justice Ward, about the difference between an independent contractor and the relationship of employer-employee, it is, we submit, very surprising if the independent contractor defence, as it's sometimes described, has been, as it were, removed at a stroke by this judgment. The court did not say so, because by saying the independent contractor distinction was no longer an answer, they would be removing more than a century's worth of established law. And they failed to make it clear, we respectfully submit. What our submission is, the proper construction of this judgment, is that the court was endeavouring to assist in future cases, not by providing a statutory type test, but by giving some of the indications where there was a case on the borderline, what features might help in determining whether in truth this was a relationship of independent contractor, or as here, where they considered it to be more like an employer-employee relationship, or indeed, as they say, closer than the employer-employee relationship.
So one way of looking at it is whether the independent contractor status is a trump card or a factor. And if you can establish that the so-called employee is an independent contractor, shorn of all of the incidents of employee, then one can understand that it would be, as I say, a trump card. On the other hand, if it partakes of some of the characteristics of independent contractor, and some of the characteristics of employee, then it should operate as no more than a factor. Would you agree?
With respect, no. Although trump card sounds a little brutal, perhaps, in terms of the analysis, in effect, we say that is the law. The law has to be clear, and has been clear for many years. If somebody is in truth, on proper analysis, an independent contractor, where I would perhaps accept it is there may be some cases where the facts make it more difficult to conclude immediately that one falls into one category or another. Hence, as it were, the position that was identified in Cox and in this case, and we're coming to Cox shortly, of something that was akin to employment or to be considered as employment. But what we do say, and here we beg to differ from the argument advanced on the other side, is that this case and cases following have not swept away the importance and the classification of an independent contractor. They've simply provided guidance in the modern world as to how one identifies when something is more properly regarded as akin, which is in effect employment, as opposed to independent contractor. But the case has done nothing to take away that established law. And if it was going to take away that established law, one would have expected the court to say so in terms. Can I then turn, my lady, my lords, to the case of Cox, and this is at MS 382. And of course, I know that this is a familiar territory for my Lord Reed and Baroness Hale, but there have been a number of cases since, so not every single word may be immediately recalled. But so I should...
Lucky if we remember the next week.
So next day.
If I may remind the court of one or two aspects of the case. The court may remember, in any event, that the claimant was a catering manager in a prison, and during the course of working, a heavy bag of rice was dropped on her back by a prisoner who was working in a therapeutic capacity, or as part of his prison, his tasks. And the question was whether or not there was liability on the part of the Ministry of Justice for the negligence of that prisoner. The judge had found the prisoner had been negligent, but held that the defendant was not vicariously liable for that negligence. The Court of Appeal allowed an appeal by the claimant, and then the defendants appealed to this court. The head note at 382 shows that vicarious liability in tort was imposed on the defendant in respect of the act or omission of another because of his relationship with the tortfeasor and the connection between that relationship and the act or omission in question. That a relationship could give rise to liability even in the absence of a contract of employment, that essential factors were that the tort had been committed as a result of activity being undertaken by the tortfeasor on behalf of the defendant, that the activity was integral to the defendant's business activities, and that the defendant, by employing the tortfeasor to carry out the activity, had created the risk of the tort being committed by the tortfeasor, that those criteria had been designed to ensure that liability was imposed where it was fair, just and reasonable to do so, and where they were satisfied it was not generally necessary to conduct a separate assessment as to the fairness, justice and reasonableness of the result in the particular case, but that it might be valuable to do so where the case had not previously been the subject of an authoritative judicial decision. And I'll come to that passage. It's an important passage, we say, in Lord Reed's judgment. And it does, in our submission, very much reflect other case law on the law of negligence, where the courts have indicated that what is in other contexts a Caparo-type analysis, looking at fair, just and reasonable, is not an exercise that should be done except in cases where there isn't some clear precedent. Rather, the better approach is to argue by analogy with decided cases, rather than, as it were, starting from scratch and saying, is this fair, just and reasonable? Can I take the court to 389, MS 389, towards the bottom of the page, under the heading Christian Brothers case, where my Lord says, the vicarious liability in tort is imposed upon a person in respect of the act or omission of another individual because of his relationship with that individual and the connection between that relationship and the act or omission in question, leaving aside other areas of the law where vicarious liability can operate, such as partnership and agency. The relationship is classically one of employment, and the connection is that the employee committed the act or omission in the course of his employment, that is to say, within the field of activities assigned to him. 16, it has, however, long been recognised that the relationship can give rise to vicarious liability even in the absence of a contract of employment, for example, when an employer lends his employee to a third party. The third party may be treated as the employer for the purposes of vicarious liability. In recent years, the courts have sought to explain more generally the basis on which vicarious liability can arise out of a relationship other than that of an employer and employee. And the general approach to be adopted in deciding whether a relationship other than one of employment can give rise to vicarious liability, subject to there being a sufficient connection between that relationship and the tort in question, was explained by this court in the Christian Brothers case in the judgment given by Lord Phillips, to which I've just referred. The judgment was intended to give greater clarity in an area of law which had been unsettled for a number of years. Page 391,
I just wonder, just before we get to
yes.
You didn't take us to paragraph 47 of Lord Phillips' judgment, but I see I quoted it in paragraph 19 of Cox. And it's significant, perhaps, because you see the shift from paragraph 35 of Lord Phillips' judgment, where he lists what he calls policy reasons that usually make it fair, just, and reasonable to impose vicarious liability on the employer when these criteria are satisfied. There's a sort of move there between policy reasons and criteria. And when you get to paragraph 47, he describes them as incidents of a relationship, and then goes on to say that where the defendant and the tortfeasor aren't bound by a contract of employment, but their relationship has the same incidents, that relationship can give rise to vicarious liability. So one can see, I think, a move in his judgment between the idea of these 5 factors being policy reasons to the taking on the character of to use his other word, criteria for the imposition of vicarious liability. At least, the critical questions, of course, is this when we're outside the clear categories.
Yes. They've been described as criteria or factors, I think,
Yeah.
or indicia.
Yeah.
But they help in the analysis where you are in that grey area or semi-grey area when you're seeking to identify. That we submit. I didn't read it out, not as it were to glide over it, but I knew that it's set out in all the printed cases,
Yeah.
and it's referred to again here.
Yes, of course.
And it's analysed in some particular detail, and rather than read it out, I thought it was reasonably clear.
How do you regard, are they factors to be applied to each case, depending on the relevance to the circumstances of each case?
Our submission is that on the facts of this case, and indeed consistent with the law, Dr. Bates was an independent contractor, and that is the end of the inquiry. That is the established law.
So you don't apply the 5 criteria, indicia, factors, or whatever they're called, to an analysis of his relationship with Barclays?
Our primary submission is that the independent contractor defence is made out here. Our secondary submission is, which we put in the alternative, is
Yes, I think that's in your printed case.
if we're wrong about that, and then we say that subject to various qualifications, these are factors which clearly must be part of the analysis, although not to be construed like a statute, and that they may help to identify those cases where there is some doubt as to whether a particular relationship fits into one or other category. Yes, I was referring the court to Lord Reed's judgment in Cox, and at page 390, and then at page 391, Lord Reed came to deal with the 5 factors, as they are then described by my Lord at paragraph 20. My Lord said that they are not equally significant. The first, the defendant is more likely than the tortfeasor to have the means to compensate the victim and can be expected to have insured against vicarious liability, did not feature in the remainder of the judgment and is unlikely to be independent significant in most cases. We have 1 or 2 submissions to make of our own in respect of that, but for the moment I'll simply intend to draw the court's attention to what my Lord said. It's of course true that where an individual is employed under a contract of employment, his employer is likely to have a deeper pocket and can in any event be expected to have insured. Neither of these, however, is a principal justification for imposing vicarious liability. The mere possession of wealth is not in itself any ground for imposing liability. As for insurance, employers insure themselves because they are liable. They are not liable because they insured themselves. On the other hand, given the infinite variety of circumstances in which the question of vicarious liability might arise, it cannot be ruled out that there might be circumstances in which the absence or unavailability of insurance or other means of meeting a potential liability might be a relevant consideration. And the 5th of the factors, that's the control factor. The tortfeasor, greater or lesser, no longer has the significance it was considered to have in the past. And I read out the relevant paragraph of Lord Phillips's judgment and the reasons that he gave as to why that might be the case. In particular, the ability to direct precisely what an employee does may not mean that there's not employment. And then just going down the page just below letter F, accordingly, as Lord Phillips stated, the significance of control is that the defendant can direct what the tortfeasor does, not how he does it. So understood, it is a factor which is unlikely to be of independent significance in most cases. On the other hand, the absence of even that vestigial degree of control would be liable to negative the imposition of vicarious liability. And then my Lord considered the 3 factors, the other 3 factors, the remaining 3 factors. Having referred to fairly ancient cases, said of the second one that the tortfeasor's activity is likely to be an integral part of the business activity of the defendant. We say that's an extremely useful way of looking at this. Is the tortfeasor, is he an integral part of the business activity of the defendant? It's long been regarded as a justification for the imposition of vicarious liability on employers. The same could be said for those in this grey area, on the basis that since the employer's activities are undertaken as part of the activities of the employer and for its benefit, it's appropriate the employer should bear the cost of harm wrongfully done by the employee within the field of activities assigned to him. The third factor, that the defendant, by employing the tortfeasor to carry on the activities, will have created the risk of the tort committed by the tortfeasor, is very closely related to the second, since the risk of an individual behaving negligently or indeed committing an intentional wrong is a fact of life. Anyone who employs others is likely to create the risk. The essential idea is that defendants should be liable for torts that may be fairly regarded as the risks of his business activities. Can I then take the court to MS 393, where Lord Reed was commenting on Lord Phillips's judgment. He said, Lord Phillips, paragraph 27, then consider the facts of Christian Brothers. And then my Lord goes on to rehearse what I've already referred to, and indeed makes the point that the Brothers in the Institute was closer to that of an employer and employee, and the relationship was therefore sufficiently akin to that of an employer to be capable of giving rise to vicarious liability. And then at paragraph 29, MS 394, my Lord said this, It is important, however, to understand that the general approach which Lord Phillips described is not confined to some special category of cases, such as the sexual abuse of children. It is intended to provide a basis for identifying the circumstances in which vicariously liability may in principle be imposed outside of relationships of employment. By focusing upon the business activities carried on by the defendant and their attendant risks, it directs attention to the issues which are likely to be relevant in the context of modern workplaces, where workers may in reality be part of the workplace. And I stress those words, in reality be part of the workforce of an organisation without having a contract of employment with it, and also reflects prevailing ideas about the responsibility of businesses for the risks which are created by their activities. It results in an extension of the scope of vicarious liability beyond the responsibility of an employer for the acts and omissions of its employees in the course of their employment, but not to the extent of imposing such liability where a tortfeasor's activities are entirely attributable to the conduct of a recognisably independent business of his own or of a third party. Now, a business or medical practice, we submit, should be read, as it were, synonymously. An important consequence of that extension is to enable the law to maintain previous levels of protection for the victims of tort, notwithstanding changes in the legal relationship between enterprises and members of their workforces, which may be motivated by factors which have nothing to do with the nature of the enterprise's activities or the attendant risks. Now, I may be wrong, but I read that passage as my Lord saying, well, the court has to be astute to look at the realities of an employment situation so that a claimant is not thereby unable to bring a case against what is in truth an employee of an employer because of the changes in working practice. I think my learned friend puts a rather different construction on those words.
Well, perhaps the language at letter D, where I spoke about workers being in reality part of the workforce, is perhaps, I was perhaps trying to avoid having to use the words employee in the course of employment, yes. Just because that might be tied to a contractual relationship.
You say the dichotomy in this paragraph is between someone who is in reality part of a workforce and someone who is in reality a recognisably independent business.
Precisely, my Lord, yes. And if I could take the court down the page where my Lord says this just below letter G, it need not therefore be a business or enterprise in any ordinary sense, nor need the benefit which it derives from the tortfeasor's activities take the form of profit. This is a comment on the Priest case in English. It's sufficient there is a defendant which is carrying on activities in the further of its own interests. The individual for whose conduct it may be vicariously liable must carry on activities assigned to him by the defendant as an integral part of its operation and for its benefit. And then there is a reference to the case of via systems. I think my learned friend will take you to that. That was the case where the court had to consider whether it was an absolute rule that there could not be two tortfeasors in the situation that prevailed in via systems. And the court decided, the Court of Appeal, that there was, on the facts, such close control by the employer that it would be appropriate to say that there was liability. And my Lord said the other lesson to be drawn for via system is that the defendants cannot avoid vicariously liability on the basis of technical arguments about the employment status of the individual who committed the tort. Quite so. We say that ours is not a technical argument about status at all. It's a clear own practice, own business, and therefore we don't need to rely on any technical arguments. In a sense, we would also make this comment very respectfully that all this helpful analysis giving guidance to judges would almost be unnecessary if the independent contractor defence had entirely disappeared, as indeed the learned friend argues. And as indeed it appears that Lord Justice Irwin, although not so clear what Mrs. Justice Davis thought about this, is in fact the position, where the Court of Appeal appear to have concluded that you ignore the independent contractor status, you simply look at these 5 indicia, factors, criteria, or whatever, and decide the case according to those criteria. Can I now turn to the Woodland and Swimming Teachers case, which is at MS 567. This was a decision in 2014 by this court and concerned a claimant who was a pupil at a school who suffered a severe brain injury during a swimming lesson. The lesson was supervised by a swimming teacher and a lifeguard, both who were employed by an independent contractor who organised and provided the lesson. And deciding the issue as a preliminary point, the judge had held that part of the claim which alleged that the local education authority owed the claimant a non-delegable duty was bound to fail. The Court of Appeal held its decision, but this court allowed the appeal that the essential feature of the non-delegable duty of reasonable care was that the defendant had control over a vulnerable claimant for the purpose of performing a function for which the defendant has assumed responsibility. Clearly, we're not concerned today with a non-delegable duty argument, but nonetheless, it's appropriate, we respectfully submit, to make 1 or 2 brief references to the judgment to see whether they cast any light on the issue before this court. The speech of Lord Sumption and the relevant passage is at page 6, MS 602. At paragraph 3, under the heading Non-Delegable Duties, in principle, liability in tort depends on proof of a personal breach of duty. To that principle, there is at common law only one true exception, namely vicarious liability. Where a defendant is vicariously liable for the tort of another, he commits no tort himself and may not even owe the relevant duty, but is held as a matter of public policy for the tort of the other. The boundaries of vicarious liability have been expanded by recent decisions of the court to embrace tortfeasors who are not employees of the defendant but stand in a relationship which is sufficiently analogous to employment. Various Claimants versus Catholic Welfare. And he then goes on to say, the issue on this appeal, however, has nothing to do with vicarious liability, except in the sense that it only arises because there is none.
Don't you want the last sentence of the paragraph too?
It is never extended to the negligence of those who are truly independent. I'm so grateful to my lady. I think it is in our printed case, but a temporary oversight.
Well, the same thought was going through my head.
Super restraint.
Yeah, a very subtle piece of advocacy. But it is never extended to the negligence of those who are truly independent contractors, such as Mrs. Stopford appears to have been in this case. And what my learned friend says in this, in her submission, is that all this is obiter, and that since the case was about non-delegable duties, the court need not pay too much attention to that. At page 613, at 583 in the case, there is a passage at the bottom of the page where, just above letter H, the defendant is not usually in control of the environment in which the injury is caused by an independent contractor. That is why, as a general rule, he is not liable for the contractor's negligence. Where a non-delegable duty arises, the defendant is liable not because he has control, but in spite of the fact that he may have none. The essential element, in my view, is not control of the environment in which the claimant is injured, but control over the claimant for the purposes of performing a function for which the defendant has assumed responsibility. And then my Lady Baroness Hale also delivered a judgment in this case. And if I could respectfully draw the court's attention to paragraph 34 of her judgment, which is at page 618. No one in this case has seriously questioned that if a hospital patient is injured as a result of a nurse's carelessness, it matters whether the nurse is employed by the hospital or by an agency. Or if a pupil at school is injured by a teacher, it matters whether the teacher is employed by the staff or is self-employed. Yet these are not employees of the hospital or school, nor can it be said their relationship with the school is akin to employment, in the sense in which the relationship with the individual Christian brothers to their order was. The reason why the hospital or school is liable is the hospital is undertaken to care for the patient and the school is undertaken to teach the pupil, and the responsibility is not discharged simply by choosing apparently competent people to do it. The hospital or school remains personally responsible to see that care is taken in doing it. We submit that there's nothing in this case to indicate, insofar as it was relevant, that the independent contractor defence, which is a matter of shorthand, I'll call it, is no longer the law. Can I then take the court to the case of Armes, which is at MS 319. Just refer to Christian Brothers.
You would probably say that defence is not the right way to describe. It's a matter of principle.
Yes. A lot of the academics use the word defence in inverted commas when describing it. It's a shorthand, but it is a matter of principle. Your knowledge, I entirely agree. If I do slip into describing it as defence, it's without prejudice to that submission, as it were. The case of Armes was a case about the liability of the Nottinghamshire County Council for the negligence or the deliberate acts of foster parents. The claimant had been abused by foster carers who'd been placed there by the local authority, and there had been a decision of some antiquity which was effectively overruled by this decision. The judge at the first instance had dismissed, so I should pause there just above letter E. She claimed that the local authority was liable either vicariously or because it owed her a non-delegable duty to ensure that she was protected from harm, and alleging the authority had failed to exercise reasonable care both in the selection of foster carers and in the supervision of the placements. And this court held that the local authority had statutory duties to provide accommodation and a considerable number of other duties in the complex web of statutory obligations, and that this, considering Woodland, meant that there was not liability, as it were, in a general duty, which would be too demanding, but for the purpose of vicarious liability, this is two, the relevant activity of the local authority was to carry out its statutory duties in regard to children in its care. And in order to discharge their duties, it recruited, selected and trained persons who were willing to look after children in their homes as foster parents. The foster parents were expected to carry out their duties in cooperation with the local authority. Social workers were involved in making decisions concerning the children, that therefore foster parents could not be regarded as carrying out an independent business of their own. Providing care to children as an integral part of the local authority's organisation of its child care services. Considering the local authority's statutory responsibilities and the manner in which they were charged, it was impossible to draw a sharp line between the activity of the local authority responsible for the care and promotion of the claimant's welfare and that of the parents, foster parents. So vicarious liability was established. And I take the court to the judgment, my Lord Reid, at MS 334. At paragraph 30, my Lord says this: liability in tort normally depends on the breach of duty owed by the defendant, a breach of duty owed by the defendant to the claimant. The only true exception to that principle under the common law is vicarious liability, where for reasons of policy the defendant has held liable for the breach of duty owed to the claimant by a third party. There cannot, however, be any rationale for imposing vicarious liability on the defendant where he is directly liable for the harm caused by the third party. It therefore makes sense to consider the scope of the defendant's own duties before considering whether vicarious liability may exist. And my Lord refers at paragraph 33 to Lord Sumption's having identified two broad categories of case and quotes this, a large and varied anomalous class of case in which the defendant employs an independent contractor to perform some function which is either inherently hazardous or liable to become so in the course of his work. And the present case does not fall within that category. And at paragraph 34, referring to Lord Sumption, went on to identify a number of characteristic features of cases in the second category. These included the assumption by the defendant of a positive duty to protect the claimant from harm, and the delegation by the defendant to a third party of some function which is an integral part of the positive duty which he has assumed. In such a situation, the defendant may delegate the performance of the function, but he remains under a duty to ensure the function is performed. And he then quotes Lord Sumption again, in the absence of negligence of their own, for example, will not be liable for the negligence of independent contractors, where on analysis their own duty is not to perform the relevant function, but only to arrange its performance. Now, if my learned friends are right, of course, the liability for the negligence of independent contractors is no longer the law. We say it's somewhat surprising that this was a case about vicarious liability, albeit that the Woodland case was about non-delegation. Here, the passage from Lord Sumption is being referred to in the context of vicarious liability, without, as it were, in any way saying that the independent contractor principle was no longer the law. And my Lord, at paragraph 36, referred to the 5 criteria set out by Lord Sumption, thus intended to identify circumstances in which the imposition of non-delegable duties. There were 5 criteria there, as well as in the Christian Brothers case. It's important to bear in mind Baroness Hale's cautionary observations that such judicial statements are not to be treated as if they were statutes and can never be set in stone. Like other judicial statements, the criteria articulated may need to be reconsidered and possibly refined in particular contexts. That does not, however, mean that it's routinely necessary for the judge to determine what would be fair and just as a second stage of the analysis. As was made clear by this court in Cox, in relation to vicarious liability, having recourse to a separate inquiry into what is fair, just and reasonable, not only unnecessary, duplicative, but is also apt to give rise to uncertainty and inconsistency. At page 340, my Lord is considering the case of Cox, and says that this case involving foster parents, and this is just above letter E, the present appeal, like the case of Cox, is concerned only with the first of those questions, there being the 2 questions or 2 stages. It's conceded that if the relationship between the local authority and the foster parent is one which can give rise to vicarious liability, then the abuse of the child is a tort for which vicarious liability is imposed. Under the doctrine of vicarious liability, the law holds a defendant liable for a tort committed by another person. Plainly, the doctrine can only apply where the relationship between the defendant and the tortfeasor has particular characteristics justifying the imposition of such liability. The classic example of such a relationship is that between employer and employee. As was explained in Cox's case, however, the doctrine can also apply where the relationship has certain characteristics similar to those found in employment, subject to there being a sufficient connection between the relationship and the commission of the tort in question. And that last phrase is, of course, being stage 2 rather than stage 1. And then my Lord is considering the various factors and says at paragraph 57, MS 341, it was explained, it's just above letter F, that those factors are interrelated and reflect the principal justifications which have been put forward in our law for the imposition of vicarious liability. In a sense, it may be more helpful sometimes when looking at Lord Phillips's 5 criteria to look at them more as a whole, albeit that they are divided up, to see whether they help to produce an overall analysis rather than to deal with them seriatim, where they can produce some rather odd results. And my Lord also said at paragraph 58 at MS 342, finally, as was explained, words such as business do not confine vicarious liability to activities of a commercial nature. This is apparent from Cox's case. And, of course, we say that a medical practice is not to be distinguished from a business for the purposes of this analysis. So, can I now come to a case that was referred to by the Court of Appeal, but not with feeling that it gave them any much assistance. And I would respectfully submit that it perhaps does give some assistance to this court. It's the case of Kafaji, which we can find at 466, a decision of the Court of Appeal. It was reached in May of 2018.
I'm sorry, could you just...
It's MS 466, my lady, and
Thank
it's
you.
tab 5 of the
Thank
authorities bundle. This was an appeal. We get this from 467 from the county court. By the decision, the district judge dismissed the appellant's claim for various torts, having been committed by two bailiffs for whose actions it was argued the respondent company, the JBW Group Limited, were liable. Lord Justice Singh refers to the judgment of the district judge at paragraph 7 and rehearses what the judge described as the issue, which we see at paragraph 7. Is the defendant vicariously liable for the actions of Mr. Boylan and Mr. Fenwick? They were the bailiffs. This will depend on whether Mr. Boylan and Fenwick were employees of the defendant or merely subcontractors. If Mr. Boylan and Mr. Fenwick were subcontractors, the liability of defendant would have to be found in breach of a non-delegable duty. No such duty or breach of it has been pleaded. Lord Justice Singh went on to consider recent authorities on vicarious liability. If I take the court to MS 470, at paragraph 21, he said this: in recent years, the courts have had to address the question whether there can be vicarious liability even when there is no relationship of employment in the strict sense, but where there is something akin to employment. However, it's important to note that this development has not undermined the conventional distinction between a contract of employment and a contract for services, which continues to be relevant in the vast majority of cases. That was his interpretation of the law, and we say that's correct. At 478, MS 478, the judge goes on to, at the bottom of the page, an analysis of the main issues. He says, in the present case, it is submitted the essential facts of this case are straightforward and no different from those which will lead to the conclusion in the vast majority of cases that there is nothing akin to employment. And he goes on to deal with these submissions, and these are important on the facts. At paragraph 50 at MS 469, the respondent is a judicial services company which subcontracted the collection of certain council tax debts which were owed to the London Borough of Wandsworth. Mr. Boylan, he ran his own business. He could turn down work that was offered by the respondent. As Ms. Eva said in evidence, this was not ideal from the respondent's point of view because Mr. Boylan could cherry-pick the work he wanted to do. And it is, we say, of some significance that he could turn down work. And also we pick up from paragraph 53 that he had worked for other clients. That, of course, is the position here with Dr. Bates. As Mr. White submits, Mr. Boylan was at liberty to conduct the collection of debt in whatever legal manner he saw fit without control from the respondent. He was at liberty not to conduct the collection himself, but to share the work with another person. And just going down the page, I think it is also of significance he worked for other clients. As Mr. White submits, it's telling there was no reason in principle why Mr. Boylan could not have been engaged directly by the London Borough of Wandsworth. Well, that's obviously not precisely analogous here. Finally, Mr. White submits there was not in the present case even that vestigial degree of control to which Lord Reed made reference, paragraph 21. So paragraph 56, Lord Justice Singh says this: in all the circumstances of the case, it's clear in my view that this is not one of those cases in which the relationship between the respondent and two bailiffs, Mr. Boylan and Mr. Fenwick, can be regarded as being akin to a relationship of employment. Indeed, in the case of Mr. Fenwick, there was no contractual relationship with the respondent at all, as the district judge found. Lord Justice Irwin agreed with what he said, but felt able, when he was in his judgment in this case, to say that he did not think that it was analogous or particularly helpful. What we would say is that, although the facts, of course, are different, nonetheless, it reflects what is a continuing analysis of the law in all the cases we've seen, none of which in any way seek to doubt the fact that if you are an independent contractor, there is no vicarious liability. The final case I'd like to take the court to, although there are other cases referred to in our printed case, but I don't think it's necessary to take the court to it, is a decision from Singapore. The decision can be found at MS 657. I think it's been described variously as the Court of Appeal or the Supreme Court. On careful examination of the hierarchy of courts in Singapore, I think they're probably both right. It's the final Court of Appeal in any event, and the most senior judges are involved in this decision. In fact, we have also provided at MS 123, Appeal Bundle 3, the decision of the judge below, which I won't take you to it, but it's a very valuable analysis of the law and takes into account all the authorities that this court has before it, and indeed deals with the so-called independent contractor defence in a way which we say is entirely consistent with our submissions. But the decision of this court, the judgment was given by the Chief Justice. The case is Huat Singh and another versus Munib Mohammed Madni. Paragraph 1 at MS 659. This was an appeal against the decision of the learned Judicial Commissioner, the judge, who dismissed the appellant's claim against the respondent for damage to their property. The damage was the result of demolition works carried out by a contractor on the respondent's premises. It was not disputed that the contractor had been negligent. The question is whether the respondents too were liable. And then there's a reference to the High Court decision to which I've just referred. The three principal issues corresponding to the three heads of liability arose for our determination in this appeal. A, whether the respondents were vicariously liable for the negligence of their contractor, the vicarious liability issue. B, whether the respondents had exercised reasonable care in selecting and appointing the contractor to undertake the demolition works. It is perhaps worth stressing that that is, of course, one of the bases on which it is sometimes possible to fasten liability on a defendant on the basis that, all right, there may be an independent contractor, but you should never have selected this particularly unreliable or inappropriate independent contractor.
Of course, that's a species of primary liability rather than vicarious liability.
Yes, it is, precisely. Whether the respondent owed the appellants a non-delegable duty to ensure that the contractor took reasonable care in performing the demolition works. So all the, as it were, the possible routes to liability were in play in this particular case. Can I take the court to the vicarious liability issue, which can be found at MS 671. The judge refers to the appellant's argument, which includes reference to Christian Brothers and Cox. They submitted a multifactorial approach should be applied to determine whether vicarious liability should be imposed in relationships such as the present, which fell outside an employment relationship. According to the appellants, vicariously liability could be imposed on a defendant even for an independent contractor's negligence in appropriate cases. Now that's precisely the argument which, as I understand it, is being advanced against us today, which is that one looks at a multifactorial approach and an independent contractor, there may be liability on that basis.
I'm sure you know what Lord Sumption said about a multifactorial approach at his valedictory.
I'm afraid I didn't quite catch that. I don't know if he was approved of it, I shouldn't think.
Well, he said he had various things, but what he said about a multifactorial approach is it meant the judge could do what he liked.
Yes.
I'm not saying that I agree with him, but...
No. It's as well to know what he said.
It hasn't entered the jurisprudence of the court just yet.
Not yet.
Well, I rather hope it doesn't, but that's not a matter for me. In any event, can I take the court to their decision, which begins at 677, and at paragraph 41, the first basis on which the appellants mounted their case was the doctrine of vicarious liability, which is a form of secondary liability, entirely picking up the point my Lord Kerr mentioned, the difference between secondary and primary liability. In brief, under this doctrine, the law holds a defendant liable for the negligence of another, even if the defendant has not been negligent at all. This is plainly an uncommon situation, and it's important to understand the proper limits of the doctrine and the circumstances in which the law will impose such liability. Under the orthodox analysis, it's always been recognised that a prerequisite for the imposition of such liability is the existence of a special relationship between the defendant and the tortfeasor, such as will make it fair, just, and reasonable to impose liability. Equally, under the orthodox analysis, whatever might be the nature of that special relationship, its very antithesis is a relationship on which the tortfeasor is engaged by the defendants as an independent contractor. The reason for this will become evident when the underlying rationale of the doctrine of vicarious liability is properly understood. In the present case, the appellants, despite accepting that the tortfeasor aesthetix was an independent contractor, nevertheless contended the respondents could be made vicariously liable for the negligence. They said this was because the courts had eschewed the law's traditional focus on the employment relationship as the primary basis for imposing vicarious liability in favour of a multifactorial approach that examined whether it was just to impose such a liability in the circumstances of the case concerned. This is a mistaken view of the law. So the Chief Justice said, as we will elaborate before, there are two separate inquiries to be undertaken when determining whether vicarious liability should be imposed. The first examines the nature of the relationship. While the law does not confine this to a relationship of employment, it remains necessary to establish a relationship of sufficient closeness, such as it would be fair, just, and reasonable to impose liability on the defendant for the torts of another. Indeed, a proper understanding of the cases cited by the appellants will reveal that where the courts have been prepared to find vicarious liability outside the context of an employment relationship, the relationships within which this has been done have all been closely analogous to employment relationship and bear many of the same features so as to make it fair, just, and reasonable to impose such liability. Further, as we indicated earlier, the fact that the tortfeasor is an independent contractor will generally be sufficient in of itself to exclude the application of the doctrine of vicarious liability. And then paragraph 44, talking about the second inquiry, and he says at the end of paragraph 44, this is a second and distinct part of the analysis, which is only reached if the claimant can first establish the existence of a special relationship between the defendant and the tortfeasor. As the appellants failed at the first hurdle, the second inquiry did not arise at all. I should make it clear that the court considered, and we can pick this up at 681, the 5 questions, factors, indicia from Christian Brothers, and considered their application in some particular detail. And if I could take you on to 687, paragraph 62. We earlier stated that it remains necessary to establish the existence of a special relationship between the defendant and the tortfeasor in order to mount a claim under the doctrine of vicarious liability. In this regard, the factors mentioned were relied upon by the appellants do not present a new and analytical framework for determining whether vicarious liability should be imposed. Rather, as is clear from the summary of Lord Phillips' analysis, his lordship was merely explaining some of the reasons why the law is prepared to impose liability on a defendant for the tortious acts of another in certain circumstances. To put it simply, the criteria listed above help to guide the court in determining the types of relationships within which it would be fair, just, to impose liability. In that context, Lord Phillips recognised that it would be wrong to take a rigid approach and confine the application to situations where there was an employment relationship. And the facts of Christian Brothers held that it was not one of employment, but was closely analogous to it. And 63 says this, hence why we accept the Christian Brothers case and Cox recognised that the doctrine of vicarious liability can be applied outside the strict confines of an employment relationship. It becomes evident when one examines these judgments more closely that their essential contribution was, and we quote this in our printed case, to fine-tune the existing framework underlying the doctrine so as to accommodate the more diverse range of relationships which might be encountered in today's context. And then at paragraph 64, MS 689, Seen in this context, it will be apparent that while Christian Brothers and Cox presented a renewed and more fine-grained method for discerning the types of relationship which may give rise to vicarious liability, they ultimately do not detract from the normative roots of the doctrine governing such liability. In keeping with this, it has to be said that the cases cited by the appellants do not suggest can be imposed on the defendant for the lapses committed by a person who was engaged as and this is the judge's emphasis, an independent contractor. And indeed to do so would be antithetical to the doctrine's very foundations, and it is therefore unsurprising that in Cox, Lord Reed explicitly cautioned in no uncertain terms that although the approach espoused in Christian Brothers extended the scope of vicarious liability beyond the employment context, this was, quote, not to the extent imposing such liability where a tortfeasor's activities are entirely attributable to the conduct of recognisably independent business of his own or third party. And he then went on to conclude there is nothing fair, just and reasonable imposing secondary liability on a defendant in such a situation. He also makes, and this is the final point I'm going to take from this case, quite an interesting point about what is described at MS 693, a but-for causation. One of the criteria which taken on its own, which is as a result of the acts of the putative, the defendant putatively liable, there was an introduction of the claimant to the tortfeasor. We say in our printed case, well, that may be the sine qua non of that, but in a sense that really doesn't carry the matter very much further. And what he is talking at paragraph 70 is this: second, to the extent that it was suggested that because the works carried out on the respondent's property were an enterprise which properly belonged to the respondents, the risk should rightly be borne by them. This was flawed for a fundamental reason. The argument rested on the notion that as long as a factual or but-for causation was established between the defendant's relationship with the tortfeasor and the commission of the ensuing tort, vicarious liability could be imposed. That was simply not the law. It is not any relationship with the defendant and the tortfeasor will suffice, and an independent contractor relationship will generally exclude the application of the doctrine altogether, nor will but-for causation suffice. So, My Lady, my Lords, we submit that those cases and those authorities point clearly in favour of the continuing existence of an answer in this case that Dr. Bates was an independent contractor. But as I indicated, the alternative and secondary submission we make is in relation to the possibility that we're wrong in this submission and that the proper approach is to apply an analysis of the situation by reference to these 5 factors criteria. And we deal with this in our printed case. And may I refer the court briefly to it? And I haven't got much to add to what we've said, but I will, if I may, just point out 1 or 2 points. This comes in the core volume at MS page number 61. Just before we get on to the misapplication of the 5 factors, we do point out that our submission is that it makes no difference to the analysis that this was an intentional assault. And we make the point that although, as I indicated earlier, it's well understood that a court will bound to be extremely sympathetic to victims of abuse in any circumstances, and perhaps particularly in circumstances like this which involve an abuse of a position of authority. The law remains the same regardless of the nature of the tort. And we pose the question at paragraph 49, what if a prospective employee, and these were prospective employees, had fallen down a staircase at Dr. Bates's premises due to a defect? The question for a court would surely be whether Dr. Bates was liable, whether he was liable, depending on the facts. It would be very surprising if Barclays were vicariously liable in those circumstances. So is there a difference because it is sexual abuse rather than, as it were, a but-for cause of the accident when he or she attends the surgery and falls down the stairs. And we submit that it's important that one doesn't, out of an understandable sympathy for the victims, cause the law to take a wrong turn, as some of the academics suggest that it did when the Court of
Yes,
Appeal
but
reached this.
falling down the stairs in someone's home is emphatically different from the circumstances in this case, is it not? Barclays could not be responsible for the repair of Dr. Bates' premises. On the other hand, the argument is that they are responsible for the manner in which medical examinations are conducted. Doesn't seem to me to be an analogous situation at all.
Of course, it's different, but our submission is this, that the doctor was carrying out his practice as an independent medical practitioner, which involved the prospective employees attending his premises, where he was exercising his own independent judgment in examining and producing a report for Barclays. They were there because they were there for a medical examination. We, of course, agree with my lord that there would obviously be no liability for falling down the stairs because of a defect in the stairs. Barclays could not be held responsible unless they knew in some way that the stairs were unsafe or something of that sort. But what we say is that because there was a sexual abuse, one doesn't, as it were, change the law to take into account the natural abhorrence that one has for what occurred. I was pointing to the various 5 factors, and of course we distance ourselves a little from the 5 factors simply because, as my Lord Reid observed, they're not to be applied mechanically or slavishly, and I've made the submission that perhaps they should be, to some extent, wrapped up to enable an analysis to take place. The first is the means to compensate. It's not suggested that my clients wouldn't be able to satisfy any judgment, although we do make the point about the fact that an earlier claim would have resulted in a different result. The question of means to compensate is, we respectfully submit, a somewhat unsatisfactory way in which to look at whether there should be liability. Should the court be deciding whether or not the defendant in a particular case is a solvent company, whether they have adequate insurance? On the whole, the courts steer very much clear of this sort of analysis, and we rely very much on what my Lord Reid said in relation to the fact that they're insured does not make them liable, or even if they're uninsured, doesn't, as it were, allow them to escape liability. So we respectfully agree that with the observations of my Lord Reid, this is unlikely to be a very significant factor. And we do, of course, make the point that there was a remedy and is a remedy under the Criminal Injuries Compensation Board.
Presumably Dr. Bates will have had his own insurance as a member of the MDU or some other organisation.
Well, I think we don't know because sufficient time has elapsed. I think I'd hesitate before accepting that on the basis that I think some of the MDU's policies tend to exempt deliberate acts,
yes.
So that it is possible that he was not insured.
Yes.
Whether he had some other form of insurance.
Yes, he might be insured against negligence, but not against... Precisely.
Yeah.
We simply don't know. But I wouldn't like to say firmly that he would have been insured, because that might not be the case. The activity taken on behalf of Barclays, our point about that is that if you take it, as it were, separately, almost anything that is done for an employer is on their behalf, in the sense, why would they not engage an independent contractor? Whether it's we give an example of as a window cleaner, or an auditor, or in this case, a general practitioner, whose task was to assess the employee for employment and their suitability for life insurance. And we also point to the fact that, as Lord Justice Hamblin pointed out when giving permission to appeal in this case, engaging a medical practitioner will arise in all sorts of circumstances, although the Court of Appeal was not impressed by this particular point, whether it's for life insurance, whether it's in the course of litigation. And although one would not expect Of course, one certainly would not expect a doctor to abuse their position. The fact is that that doctors in any sort of circumstances could, if they wished to abuse that position, do so. And that of itself, we submit, is not a sound basis on which to find that there is a sufficient connection to make a liability to be established. The question of integration, which we perhaps say is almost the most important aspect of this, we respectfully submit the Court of Appeal really failed to grasp with this submission, and it failed to deal with what we quote from Armes as being the question of, was this an independent business of his own, or independent business or practice? And it clearly was. The Court of Appeal thought that the selection of suitable employees was very much part of the business of Barclays. Well, clearly it follows that a medical practitioner, being an independent medical practitioner, is not part of banking business. My learned friend says in their printed case, well, there are lots of people in a bank who won't necessarily be doing frontline banking. They'll be doing other things, whether it's marketing or whatever it might be. Quite so, we accept that. But that is rather different from somebody who is not an integral part of the business and will be engaged on an ad hoc basis. And we know from the evidence that sometimes there wasn't very much work for him, and sometimes there was more work, depending on their need for employees.
Well, Barclays clearly perceived this as a vital part of their employment recruitment, that those who wish to be employed or who wish to be continued to be employed had to, at the request of Barclays, undergo a medical examination. That was, to that extent at least, integral to their business, wasn't it?
It was the engagement of employees. I don't wish to downplay it. Is of course vital. Employees are a critical part of any business, but the need for an examination, which I think stopped according to the evidence, but for a considerable period of time, and certainly whilst Dr. Bates was engaged from time to time, was going on, was to see whether they were fit to be employed. And most of those who were examined were school leavers, and they were likely to have a job effectively for life. Now, whether and I think it's not so much used nowadays, it was appropriate to do medical examinations or even helpful.
Well, it was certainly perceived at the time that Dr. Bates was acting, well, I shouldn't say acting on behalf of Barclays, because it might be suggestive of a predetermined outcome. But when he was undertaking this work, Barclays clearly perceived it to be essential to the recruitment policy that there be medical examinations.
That appears to be the case from all the evidence. On the other hand, if one thinks nowadays, I think it's probably less usual for our prospective employees to have medical examinations, but there are quite a lot of other tests that tend to be engaged. Psychometric evaluation or other independent specialists who or even using artificial intelligence, which tend to be used as part of the recruitment process rather than this rather old-fashioned way of looking at a medical examination. But that may be a difference of style. Well, it would still be employing an independent contractor to provide that particular skill and expertise.
Yeah, but we've got to look at it at the time that these examinations were taking place. And I mean, not only did Barclays regard it as vital to the recruitment practice, but also they did give instructions to Dr. Bates as to the particular features that they wanted to be informed about.
Yes, I mean, the evidence insofar as we have it, because of course, and perhaps I can, if I may, I'll take...
well, I mean, don't let me interfere with your...
The evidence appears to be this, that we have the evidence of quite an elderly lady who I think retired in 1989, who describes the process of an appointment being fixed up and in due course the form coming back. And essentially the form is it a yes or a no? then the question of the adequate GCSEs have been covered, and then employment follows. It doesn't appear from the evidence that we have to be any very close analysis of what he sent back. At this stage, we can't suggest there was, but he was given a form and carried out his examination. Now, one of the points made is, well, this form, as it were, encouraged in some way an examination which was highly inappropriate. We say that liability can't depend on the degree of specification provided to an independent contractor. Frankly, if they had simply said to him, Dr. Bates, would you carry out your own medical examination to see whether, in your view, this prospective employee is in a good, healthy state to be employed by us, and given no details at all, then there surely should be no difference as to the degree of specificity provided to a subcontractor or an independent contractor, as was the case here. In a sense, what we submit the Court of Appeal may have done is to look at one particular answer, and there's one particular form which they relied on, and rather suggest that that should have alerted them in some way, Barclays, that the doctor was in some way abusing his position. Of course, we're not concerned with negligence. Vicarious liability assumes no fault on the part of the defendant, and there would be an answer to that position. But one mustn't conflate the two. And really, in a sense, that if somebody was deliberately abusing their position, as it is alleged Dr. Bates did, it's unlikely they would alert an employer to doing so by filling in the form in such a way as to make it likely that Barclays would realise that he...
This is pertinent to the question of risk.
Yes.
The point is made in the judgments of the Court of Appeal and the Lady Justice Nicola Davis, is that Barclays, in giving instruction, for instance, about measurements of the chest on inspiration and expiration, has to be seen to have taken on a risk that sexual abuse might take place.
I think my answer to that is, my lord, that even if they hadn't done that, there was always a risk, in the sense that if you have a patient alone with a doctor or a psychiatrist, in whatever context, whether it's a medico, legal or other context, there is always a risk that this could happen. We respectfully submit the fact that there were details about chest measurements, which for all we know was perfectly standard at the time. We don't know the precise provenance of this form. Doesn't alter the position. Effectively, this was an independent examination, and would have been, the position in law would have been the same if there had been no detail other than the general instruction.
Yes.
And we deal with the question of control, and this is a matter which I think has been identified as slightly less important than it might have been, in view of the fact that, understandably, somebody may have considerable scope for doing a job, performing a task in a way that they do because of their expertise, absent any real control by those that have engaged them. Although my Lord Lord Cox thought that was one of the less important of the 5 criteria, the Court of Appeal decided that that this was really the most critical factor here, because they weren't given alternative doctors, and the fact that there was a bank logo. This really comes back to the same point that I was just making in answer to the question my Lord Kerr, which is that this was a standard form. We don't know its precise provenance, whether it came via Martins, who were the bank who Barclays took over, and Dr. Bates had already been carrying out medical examinations, or whether it was standard in industry, or whether it was Barclays' own bank. Unfortunately, time has elapsed. We can't do that, and the only evidence I have is that this looks like the form that was used at the time. That's what the evidence comes to. We say that this does not, in our submission, indicate control, and that indeed the independence is the very reason why, in our submission, they went to a doctor to provide his independent skill and care and medical expertise to provide them with the relevant report. So in our submission, even if we're wrong about in our primary submission, it is the case that properly applied, those 5 criteria should lead to a conclusion that Dr. Bates was in such a way acting on his own, so that if the independent contractor defence doesn't any longer apply, there is still no liability. I can come now, I think, to our conclusions. We submit that he was clearly, Dr. Bates, an independent contractor. The position in law is said to be trite. It's well established. It's well understood, and indeed reflected in statute. And we refer in our printed case to the Occupiers Liability Act, where the Act of an Independent Contractor are indeed so much part of our law that they are enshrined in statute. And they're based on sound principle. We accept that the law has been on the move, to use the words that Lord Phillips uses, and we also accept that Lista represented a significant change in the approach of the law to what has been described conveniently as a stage 2 issue. We also submit that the courts have responded to changing working patterns and the need to identify, and this is in all sorts of contexts, not simply in the case of vicarious liability, and we refer to the Pimlico Plumbers case, for example, in that context. And the need to identify whether somebody is employed in reality, whatever the label that may be attached to that relationship. And the courts have identified relationships which are, in their view, akin to employment, to deal with different factual situations which are outside the normal classification, such as the prisoner working in the kitchen in Cox, or the brother in Christian Brothers, or the priest in Ian English. But the engagement of Dr. Bates was neither employment nor akin to employment. And our primary submission is that none of the decisions have swept away the well-established principle that there is no vicarious liability for an independent contractor. That seems to be the understanding of all the courts that have considered this so far, and indeed the understanding in a way which we submit is helpful from the final Court of Appeal in Singapore. The academics find the Court of Appeal's solution unsatisfactory. That may or may not be persuasive, but they do provide a useful analysis which I hope will assist the court in coming to a decision in this case. My lady, my lords, unless I can assist you any further, those are our submissions.
How helpful do you think that the possible analogy with employment law is, where one has a contract of employment on one hand and a true independent contractor on the other hand, and an intermediate group of people who contract personally to perform work or services for somebody who is not in the capacity of a client or customer? Now, that intermediate category would, it seems to me, not include this case. But how helpful is that analogy? It has been suggested that the law of vicarious liability should reflect or the law of employment.
I know it has, and there's a particular article which we refer to, which suggests that it might.
That's why I'm asking you, because you didn't say anything about it.
No, I think the reason I didn't say anything about it was, having thought about it, I'm not sure that it is possible to come up with an all-embracing definition of employment, because it will depend on the particular facts before the court and the particular issue that is being decided. And therefore, I think, attractive though it may be to have a unifying definition of an employer and employee, I think I would be unwise to try and suggest one. But I do accept what I think lies behind my lady's question, which is that there may be those who are not employed but engaged to do particular work. the question of whether they are in truth employees will depend very much on the particular facts. And this echoes what I was endeavouring to submit, which is that the courts will be astute to look at the reality of a particular relationship. I know that there's one decision of my lady's which we refer to, where the question of whether somebody was a worker or not came up for decision. But I'm not sure, with great respect, whether that really helps on this particular analysis. And as my lady, I think, appreciates, we say that the court need not be concerned with those nuanced and important distinctions where you have a plain case of an independent contractor, which is our case.
But the point I'm putting to you is that there are people who are, in one sense, independent contractors, but they are employed personally to perform work or services, but they're doing it on their own account, and the person for whom they're doing it is a client or a customer. Those sorts of people are independent contractors. That there's employment law does not apply to them. But the people who are doing those sorts of services, not in business on their own account, the person for whom they're doing is not a client or a customer. Basically, they're an integral part of that person's operation. Those people are covered by employment law. It seems to me that most of what you were saying in how you identify the people who are not covered by the doctrine of vicarious liability fitted pretty clearly into that category, or into that distinction.
Well, I know, lady, that there are a number of organisations which find it more convenient to engage so-called independent contractors or people who incorporate themselves, but then act really in effect as employees of the entirely for what used to be their employer, but for various reasons, maybe tax or other reasons, asked to reconstitute themselves. I know this has caused some difficulty with the Inland Revenue, but they may be in truth employees on the facts, depending on the facts, despite their label of independent contractors, which is why I absolutely accept that one should be looking carefully at whether somebody truly is an independent contractor, as opposed to simply calling themselves an independent contractor. When properly analysed, they are an employee. And that is a case where the courts will have to decide, in truth, is this an independent contractor or not? Our submission is that although there may be such difficult cases, this is not one of them.
Thank you.
Lord Fawkes, could I just ask in that regard, is it relevant that the classification of contracts for the purposes of employment law is for very different purposes than the purposes with which we are concerned in this case?
We would say it is. I mean, the examination here is the question of the law of tort and whether it's fair and just and reasonable that there should be liability of a secondary nature because of the doctrine of vicarious liability. The other circumstances in which the question of whether somebody is an employer or an employee or properly regarded will be very different, and indeed are different in some of the examples that are in the cases before the court.
Thank you.
I mean, one tends to think of what people call the gig economy and difficult questions of classification of people who are active in that way. But the cases that have actually come before the courts in various claimants, in the Christian Brothers or Cox with the prisoner or Armes with the foster parents aren't gig economy cases at all, but simply people who cannot be classified either as independent contractors on the one hand, or in any sense as employees, at least in any conventional sense as employees.
No, it might be helpful if I very briefly, because I think I'm still within my time,
You are, yes.
Just referred to Pimlico Plumbers case, which is at MS 879. This may be possibly one of the cases that my Lord Lloyd Jones and my lady was thinking of.
Cheers.
Yeah. This is the claimant who carried out plumbing work between 2005 and 2011, initially under contract, described him as a subcontracted employee. Terms and conditions contained in the company's manual included the normal working hours, consisted of a 5-day week, the minimum of 40 hours, a company identification card when working for the company, uniform bearing the company's logo, company would issue a mobile telephone, rental charges, and in 2009 a more detailed agreement replaced the contract describing the claimant as self-employed operative providing services as agreed. Well, the court was not, if I might crudely summarise the conclusion, not impressed by this labelling and concluded that the company was exercising tight control over the claimant's performance of any job, severe terms as to when and how much the company was obliged to pay him, and a suite of covenants restricting his working activities following termination. The tribunal had been entitled to conclude the company could not be regarded as a client or customer of the claimant, and that accordingly the substantive claims of the claimant as a Limb B worker could proceed to be heard on the tribunal. The issue there was whether he was a worker and the tribunal had jurisdiction. And we submit that's a good example of this court, as it were, looking at whether it's called the gig economy or something else, looking at the realities of a case and saying, it doesn't matter what you call yourself, you're in effect an employee. Thank you.
Mr. Fuchsia?
Thank you, my lady.
Thank you. Ms. Gordon.
Please, my lady, my lords, the discussion in terms of different types of employment, quasi-employment and independent contractor identification and labelling, and the questions to my learned friend. Oh, I'm so sorry. Thank you. Sorry. Thank you. The discussion with my learned friend that the court has just had in terms of the categorisation of employer, employee, worker, independent contractor highlights the central proposition in our case that it is the wrong question to start with the question, is the employer vicariously liable for the torts of an independent contractor? The investigation as to the status, in this case, of Dr. Bates, and in any case in which vicarious liability is being investigated, needs, we say now, to come out of the investigation of the 5 criteria. And the investigation based on the 5 criteria will assist in highlighting the difficulties in labelling the tortfeasor as an independent contractor or otherwise, and the short-circuiting of the investigation by simply applying the label independent contractor to Dr. Bates, which we don't accept as the correct categorisation in any event, but simply by labelling Dr. Bates as the independent contractor and saying the independent contractor defence, as my learned friend has been describing it, still applies. So that's the end of the investigation, is simply not the correct approach to a case and of this sort. And the facts of this case demonstrate the flaws with that approach. And the correct approach we would submit is that of the learned judge and of the Court of Appeal, Lord Justice Irwin, we say was correct to say at paragraph 58 of the judgment, the reference is MS 118, but I don't think it's necessary to go to it, is in the end, the matter turns on the particular facts. And then at MS 115, he'd said in paragraph 44, I accept the submission. The law now requires answers to the specified questions laid down in Cox and Mermud, rather than an answer to the question, was the alleged tortfeasor an independent contractor? and the difficulties and the range of different employment, quasi-employment and worker types that now are more common than perhaps they were at this time, but are in any event seen, identifies the difficulty in approaching vicarious liability by starting to identify the type of relationship. And the 5 criteria are the proper approach to see, and identification of the 5 criteria and the questions that those require to be asked may, at the end of the day, identify that somebody is truly, to use Lord Sumption's words, an independent contractor. And we say the truly is important because applying simply the label independent contractor can't answer the issue. But by applying the criteria, it may be that one develops from that a identification of the relationship which is truly independent contractor and which places vicarious liability, places it outside vicarious liability if that is what comes from the investigation. But one can't start by simply saying he's an independent contractor, we need go no further. That is the answer to whether there's vicarious liability or not, because it's more sophisticated than that or nuanced than that. Depends on the facts of the case and the particular relationship between the organisation and the tortfeasor. And this case, we say, well illustrates the importance of carrying out that investigation, because applying the criteria will give you a much better answer to whether there's vicarious liability or not than looking at a formal identification of the relationship in employment terms. And we would, to some extent, agree that with what I think my learned friend was saying, that the employment status doesn't necessarily mirror or reflect whether there's vicarious liability or not. And one example may be that whilst the Armes case shows clearly that a foster parent, a local authority can be vicariously liable for a foster parent, the Employment Tribunal investigation into the status of a foster parent has so far determined that they're not even a worker, so that the two are not mirror images of each other. They're not necessarily reflecting the same result. And that emphasises the importance of the more detailed investigation.
So your submission is that you don't start with an anterior standalone examination of whether an individual is an independent contractor. You look at all of the incidents of the relationship between the avowed employer and the individual, including those characteristics which might partake of independent contractor status. But you then decide, having examined all of those globally, so to speak, whether or not vicarious liability is appropriate. Is that your submission?
My Lord, yes. And the determination, the categorisation may not provide the right answer because of the range of categorisation and the range of circumstances in which vicarious liability applies and has been found to apply by the courts, does not reflect the categorisation of the status in employment terms between the organisation and the tortfeasor. And you may, in various cases, get a different answer, which perhaps highlights the flaw in starting with, is this an independent contractor? Yes, it is, end of story. That does not fairly investigate whether the relationship, for the purposes of a particular tort and for responsibility for a particular tort, should be found. One has to look at the particular factual matrix of how that tort was performed and what the criteria tell about the relationship of integration into the business of the tortfeasor, whatever the label one might attach to their working status. it's not necessary or appropriate to start with what is their working status, what is their employment status. This is going to determine vicarious liability, because that is not how the law is developed in terms of vicarious liability. It is developed so as to have this area of investigation between clear employees and clear independent contractors, if one uses that term. There is the whole range in between. And we would say in terms of Dr. Bates, he doesn't easily fit in the conventional category of independent contractor in the sense of running his own business in any event, because what we know about Dr. Bates's activities were that he was working with what we've described as a portfolio of jobs. One job he did was to do the health employment checks for Barclays Bank, but the other jobs he did included working part-time in 2 hospital authorities on a salary and as a Schedule E employee, and we have his tax returns showing that. So his tasks in his capacity as a medical practitioner included clear employment with 2 different health authorities, included carrying out some tasks as a general practitioner in the community, for which he may have a different status, and included the health checks he did for Barclays Bank, for which we say he had yet a different status in that he was integrated into the business for the purpose of carrying that out. Therefore, to start with the man and what is his status, he's an independent contractor, is not the correct approach, or the approach that leads to the correct legal analysis for this particular case, or the proper answer in this particular case. And we refer, with reference to that, to paragraph 31 in the case of Cox, and my Lord Reed's observations in terms of defendants cannot avoid vicarious liability on the basis of technical arguments about the employment status of the individual who committed the tort. We say, in a sense, that is exactly what the appellants in this case are seeking to do. They're seeking to raise a technical argument of this is an independent contractor that provides, as they suggest, a complete defence to the liability for the torts of Dr. Bates. And that is oversimplified and not certainly fair or reasonable in the context of this case. So that the modern law of vicarious liability, through the cases that my learned friend has referred the court to, has moved away from the identifying labels of initially master and servant and then employer and employee, in line with an approach identified in Cox and affirmed in Armes, that the labels, and including the label independent contractor, is no longer a useful categorisation for the purpose of determining vicarious liability. It may be a categorisation that is useful in other senses, and we would say there is the tax world, the employment world, and the tort and vicarious liability world, which, whether that's a good thing or a bad thing, have not coincided in their identification of responsibilities or liabilities so as to exactly mirror each other, and therefore it's not helpful to look at other areas in order to identify whether there is a vicarious liability in the situation and the facts of this case, which are very specific to this case, and where, when we come to the criteria, we would say there was a much greater integration of Dr. Bates into the work of the bank, and greater control and certainly greater increase of the risk than there would be in some other situations with a similar need for medical examinations. One can't simply look at the factual situation and try to categorise it. One has to look at the particular facts of this case, and that's exactly what we say the approach of the Court of Appeal was, and was the correct approach. So in terms of Dr. Bates himself, one needs to look at his particular relationship with the bank and whether it was in the grey area between, we accept he wasn't a formal direct employee, we don't accept he was an independent contractor, we would describe his relationship with the bank as being in the area in between those two stark categorizations, and to be in an area which was, for the purposes of vicarious liability, akin to employment. There are a number of factors that the appellants rely on, which we say are not relevant to determining his status. One factor that's relied upon is the amount of time that he performed work for Barclays Bank, because he performed work for a number of other organisations. But the determination of vicarious liability, and even the determination of whether someone is an employee or not, cannot depend on the amount of time per week or per year that they spend working for that organisation, because many employees are very part-time but perfectly formal employees. You can have an employment contract to work one day a year if that's what the contract provides. So the amount of time that Dr. Bates performed work for Barclays Bank can't be determinative or necessarily even helpful. The fact that he worked for other organisations as well, again, can't be determinative, particularly in circumstances where some of the other jobs he did were clearly ones where there was a strict relationship of employer and employee, such as the work for the two Gateshead Health Authority and Newcastle Health Authority, as appears from his tax return. And so he was a Schedule E employee for those purposes, and it doesn't preclude him having, as indeed he did have, two separate employers for the purposes of the hospital work. He may have had a number of other separate employers or separate relationships that were akin to employment. And one simply can't stand back and say, as it appears the appellants seek to say, because he had a number of different jobs, he was running his own business and he was an independent contractor. That simply isn't the reality of his situation. He wasn't, in a sense, even running his own medical business, because he was doing jobs, some of which were general practice, some of which were employment health checks, in which he was the bespoke doctor for particular organisations, and some of which he was working in a hospital. He was doing, we would say, effectively piecework, which in the modern interpretation of employment was closer to that of the gig economy than that of a independent contractor running his own business. And the work that he did for Barclays Bank was hardly building his own business. It was piecework where he was paid a particular fee for the number of patients that he saw, which is much more similar to being paid a fee for the number of deliveries you do than it is to building a business and a reputation and a profit-making organisation. He was taking no risks for his own business or having the opportunity to make greater profit. He was simply doing particular examinations for a particular fee. Although it is right to say that we don't have, because the disclosure hasn't determined exactly what the relationship between him and Barclays Bank was, whether there was, we know only from the witness statements that he was paid a fee for each of the examinations he did, but we've not seen any documents as to how the relationship started. And that's probably a feature of the fact he started working for Martin's Bank before he moved to work for Barclays Bank when Martins and Barclays amalgamated, I think in the 60s. So that we simply don't accept that we're helped, that the court is helped by starting with the question, can an independent contractor be found to be the subject of vicarious liability? And the categories of self-employed persons who are helpfully described by Baroness Hale in the Bates van Winklehoff case, and there one sees the difficulty in dividing them up. Can I just take the court to that case, which perhaps helps in identifying that difficulty? It's in volume 2.
714.
It's MS 714 in volume 2.
Did you say 714?
714 in volume 2, my lady.
Thank you.
Starting at paragraph starting at paragraph 24 on the bottom of 721, first, the nature and ordinary meaning of employed by is employed under a contract of service. Our law draws a clear distinction between those who are so employed and those who are self-employed, but enter into contracts to perform work or services for others. Second, within the latter class, the law now draws a distinction between two different kinds of self-employed people. One kind of people who carry on a profession or a business undertaking on their own account and enter into contracts with clients or customers to provide work or services for them. The arbiters of Hashmouni and various cases are cited there. The other kind are self-employed people who provide their services as part of a professional business undertaking carried on by somebody else. The general medical practitioner in Hospital Medical Group in West, who provided his services as a hair restoration surgeon on a company offering hair restoration services to the public, was a person of that kind, and thus a worker within the meaning of Section 230 of the 1996 Act. Had Parliament wished to include worker class of self-employed people within the meaning of Section 4.4, it could have done so expressly, but it did not. That's identifying the difficulty. Then on page MS 725, paragraph 37, the issue came before the Court of Appeal and Hospital Medical Group and Westwood, a case which was understandably not referred to in the Court of Appeal in this case, as it was argued shortly before the hearing in this case, but judgment was delivered a few days afterwards. Hospital Medical Group Limited argued that Dr. Westwood was in business on his own account as a doctor, in which he had 3 customers: the NHS for his services as a general practitioner, the Albany Clinic for whom he did transgender work, and HMG, for whom he performed hair restoration surgery. The Court of Appeal considered that these were three separate businesses, quite unrelated to one another, and that this was a class of worker in relation to HMG. So although I've said that the employment cases are perhaps don't reflect the same categorisations, one at least sees similar problems in trying to identify whether someone is a worker, as one sees in categorising whether someone is an independent contractor, that they may be doing different tasks for different organisations on a different basis. And one can't simply say, because you're doing lots of different tasks for different people, you must be an independent contractor. And then, starting in paragraph 39, in particular, the passage starting at the bottom of page 725, equally, as Lord Justice Maurice Kay recognised in Westwood's case, one may be a professional person with a high degree of autonomy as to how the work is performed, and more than one string to one's bow, and still be so closely integrated into the other party's operation as to fall within the definition. It's the case of controlling shareholder in a company who is also employed as chief executive shows one can effectively be one's own boss and still be a worker. So that is perhaps highlighting the difficulty in simply categorising the person who works for a number of organisations as having the same status in each of the organisations that they work for, and that is highly relevant on the particular facts of this case as to the basis on which Dr. Bates provided medical reports for Barclays Bank. And one isn't helped by looking at what else he did or by saying because he did lots of other jobs, he clearly wasn't incorporated into the Barclays Bank business. And as I think I've referred to, in terms of foster parents, the Employment Tribunal decisions are to the effect that they are not workers, and yet there is now clear authority in the case of Armes that there can be vicarious liability for them. So if in that case, when I'd looked at the status of foster parents in terms of employment, one would have not found that they were anywhere close to employees. There is no contract of employment. They're not formal employees. They're not even workers for the purpose of workers' rights as far as employment tribunals are concerned. And yet, because of their integration into the work of a local authority, the local authority can be vicariously liable for them. And foster parents are perhaps another example of people who may be working for a number of different organisations. Foster parent may work for 2 different local authorities, may do private fostering as well, and their status may be different for those different tasks that they carry out. And when looking at vicarious liability, in any particular case, you would need to look at their relationship with the organisation that had placed the child with them as to what that relationship was in determining whether the organisation, albeit a private fosterer or the local authority, were vicariously liable for abuse by a foster parent of a child. That again illustrates the need for a detailed investigation of the facts of the case rather than a categorisation of their employment status as being the starting point. So that the investigation and the review of the authorities in which my learned friend has pointed to passages saying that the independent contractor is in a separate category and is in a category where vicarious liability is not applicable. we would submit is not a helpful way of approaching this case as to what the responsibility of Barclays Bank should or shouldn't be for the torts of Dr. Bates, that the appropriate approach is to start with the criteria which are now well known and look at those criteria, as indeed the Court of Appeal did in trying to ascertain the relationship. My learned friend referred to the Singapore Court of Appeal case, and it's right to say that that case was decided just before the Armes case, and I think whilst it was an analysis by a court in a different jurisdiction of the existing cases at that time, it didn't include the analysis which is now helpfully added to the body of case law from Armes, which was, I think, handed down in October, and the Singapore case was decided in September. In any event, the facts in the Singapore case are very different. The case involved property-related dispute, and the claimant's property being damaged by a demolition company, and the precise relationship between the demolition and the property owner is fact sensitive to that case. The determinative facts are at paragraph 69 and 70. I think my learned friend referred to those paragraphs. We would also say, in terms of the Kafaji case, again, the facts were very different, and it was highly relevant to that case that the bailiffs were not given any particular instructions as to how the debts should be enforced or collected. It's very different from the situation here, where Dr. Bates was given very specific instructions as to what the medical examination should involve. And when we come to the details, the young women who were sent to see him were given very specific instructions as to when to go and see him, where to go and see him, and to have the examination that he required of them, so that the degree of integration in the Singapore case will be very different from that in this case. It again highlights the importance of looking at the cases on a fact-sensitive basis to see what the true relationship is, rather than simply applying a label. I was going to now move on to the 5 criteria.
But you know what I'm going to say, don't you? Seems like a convenient moment for us to adjourn and look forward to hearing from you further at 2:00. Thank you.